welcome to my channel. Today I'm going to focus on a dilemma that barristers sometimes face, and that is when a defendant tells the barrister that he or she is guilty of the offence, but actually wants to plead not guilty.
I admit to it, but I'm going to plead not guilty.
So I'm going to focus on how barristers should navigate that situation.
I admit to it, but I'm going to plead not guilty. I am not going to prison.
Now, there are ethical obligations that barristers obviously have to adhere to, and there are specific ethical obligations that govern this particular scenario. And I think the starting point is this: barristers have a duty to their clients, and that duty is to act in the client's best interest. In doing so, barristers cannot break the law. So that's the starting point. The second ethical consideration is this: barristers also have a duty to the court. And one of those duties is to not mislead the court. So barristers cannot knowingly or recklessly mislead the court. So where there is a conflict between, on the one hand, the barrister's obligation to their client,
but I'm going to plead not guilty,
and on the other hand, their obligation to the court, the obligation to the court supersedes, prevails over their obligation to their client.
But
so a barrister has a duty of confidentiality to their client. A barrister therefore can't disclose any instructions or information that has been conveyed to him or her by their client, unless the client gives express permission for the barrister to do so. So what that means is that if a defendant tells a barrister that they committed the offence, but that they want to plead not guilty, the barrister cannot disclose the confession to the court. I want to just talk about what I mean by misleading the court. So misleading the court would be to, for example, make a statement or representation to the court that the barrister knows to be untrue. Another example of misleading the court is where, during the course of cross-examination, the barrister suggests to the witness facts that the barrister knows to be untrue or misleading. So, for example, if the barrister has been told by the defendant that he is guilty of assaulting the complainant and that he punched the complainant, if during the course of cross-examination the barrister suggests to a witness that the defendant did not punch the complainant, well, that clearly would be misleading the court. A barrister would be misleading the court if they were to put forward a positive defence inconsistent with the defendant's confession. So, for example, if a barrister suggested during the course of cross-examination that the witness was mistaken in their identification of the defendant, that would be a positive defence that would be inconsistent with the defendant's confession of guilt. You would be misleading the court if you called the defendant to give evidence at trial. So if you call the defendant to give evidence, you know that the defendant is going to be putting forward a defence. The defendant is going to be saying, I didn't commit the offence. Why else would the defendant go into the witness box? The defendant isn't going to go into the witness box and say, under cross-examination, you know what, I did it, I committed the offence, lock me up now. It's not going to happen. The defendant is going to go into that witness box in order to put forward a defence. And so by calling the defendant, allowing the defendant to go into the witness box, you are going to be complicit in misleading the court. If you were to call witnesses to give evidence on behalf of the defendant, at trial, again, you're going to be misleading the court because those witnesses are there to support a defence, a non-existent defence. If in your closing speech, you submit to the jury that the defendant did not commit the offence, again, you're misleading the court. If you suggest that someone else committed the offence, you're misleading the court. If during the course of the trial you put forward an alibi, you're again going to be misleading the court. Okay, so I know what you're thinking.
That lady's crazy. That lady is really crazy. She's so crazy.
A barrister is going to be restricted on what he or she can do for their client in these circumstances. All that the barrister can really do is to test the reliability of the prosecution case. So, yeah, you're going to be really, really restricted in what you can do for the defendant in these circumstances. If your client is adamant that he or she wants to give evidence, you would firstly have to explain to them the reason why you can't call them to give evidence. When you say you want to give evidence, what are you intending to say in court?
I'm innocent, of course.
Mr. Flynn, you've confessed to me that you committed the offence. And so if I were to allow you to go into the witness box to give evidence that contradicts what you told me, I would be breaching my ethical duties.
So?
I would be misleading the court.
I don't care.
Now, if your client says, no, I want you to call me to give evidence, well, then you're in a really tricky situation. You're going to have to explain to your client that you will have to withdraw. Mr. Flint, if you insist on wanting to give evidence, I will be left with no other option but to withdraw from your case. In other words, I won't be able to represent you because as I said, I cannot be complicit in misleading the court.
I don't care. I'm giving evidence.
Well, in that case, Mr. Flint, I'm afraid I'm not going to be able to represent you. Now, what happens when you withdraw? You have to explain to your client that you are going to withdraw. You're going to explain the reasons for withdrawing. And you would also have to explain your continuing duty of confidentiality to your client. So you would explain that to your client. Then you'd have to go into court and you'd have to explain to the judge that you've had to withdraw. Obviously, you don't give the judge the reason that you're having to withdraw because then you'd breach your confidentiality. Now, you wouldn't leave your client in the lurch. You wouldn't leave the client to represent themselves. What you would have to ask the judge to do is to grant a short adjournment to enable your client to obtain alternative representation. Now, I personally would phone my instructing solicitor and explain to the solicitor that I've had to withdraw and ask the solicitor to send somebody else to represent the client. Obviously, I'm not going to explain to the solicitor the reason why I'm having to withdraw because of the duty of confidentiality. So, those are the ethical obligations in this particular situation. It's a bit of a minefield, but always remember that you have an overriding prevailing duty to the court, not to mislead the court. So you should now understand your ethical obligations when representing a defendant who tells you that they've committed the offence but wishes to plead not guilty. See you next time.